Chapter 11, Internal Revenue Bonds, Sec. 163. Scope. In order to ensure collection of the internal revenue to which the federal government is by law entitled, many of those whose duty it is to pay those taxes are required to give bond, with surety, conditioned in effect that they will perform their duty in this respect. Internal revenue taxes are levied mainly on liquors and tobacco, so that manufacturers of, and dealers in, those articles are the principal ones who are required to give such bonds. These bonds are undoubtedly credit guarantees, in that they guarantee the payment of money, yet the collection of the taxes is surrounded by so many safeguards, and the penalties for failure are so burdensome that a loss seldom occurs. In the preceding chapters, we have been dealing with bonds where the liability varied according to the law of the several states, or according to the different forms of bonds of the several companies. It has not been possible, therefore, to point out specifically the liability in each case, but it has been necessary, by induction, to formulate general principles from which it is helped. The liability under any particular bond may be determined. The bonds which are the subject of this chapter, being required by federal authority, are uniform throughout the country, so it will be possible to consider the specific liability and risk under each bond. While the question whether or not a particular applicant is able and willing to perform the obligation thus outlined will be determined, in a measure, in accordance with the principles heretofore announced, yet some specific suggestions will be made with regard to the chance of loss under each bond. It seems unnecessary, however, to attempt to point out the risk on all the bonds that may be required in this connection, as some of them are used very infrequently, and some involve practically no chance of loss. We shall deal therefore only with those which are used most frequently. The bonds of the Internal Revenue Officers are not within the scope of this chapter. They are public official bonds and should be considered in the light of Chapter 2. This chapter is limited to the bonds required to be given by manufacturers of and dealers in articles subject to an internal revenue tax. Sec. 164. Distillers' bonds. An internal revenue tax is, by law, imposed on all distilled spirits, and, inasmuch as it would be comparatively easy for a distiller, if left free to act upon his own inclination, to dispose of the liquors distilled by him, without paying the tax, Congress has made elaborate provision to ensure payment of the taxes when due. The law provides, in the first place, that, if any person engages in, or carries on, the business of a distiller with intent to defraud the United States of the tax on the spirits distilled by him, all distilled spirits or wines, and all stills or other apparatus used or intended to be used for the distillation or rectification of spirits, found in the distillery, and all right, title and interest of such person in the lot or tract of land on which such distillery is situated, and all right, title and interest therein of every person who knowingly has suffered or permitted the business of a distiller to be carried on, or has connived at the same, shall be forfeited to the United States. S. Sec. 3281, in order to make sure that the lien, imposed by Sec. 3281, will operate on the land, and to prevent the owner of the land, if he be not the distiller, from contending that he was ignorant of the purpose for which the property was to be used, the law further provides that a person shall not engage in the business of a distiller unless he is the owner in fee, unencumbered by any mortgage, judgment or other lien, of the lot or tract of land on which the distillery is situated, or unless he files with the collector the written consent of the owner of the fee or of any mortgage or judgment creditor that the premises may be used for the purpose of distilling spirits, and expressly stipulating that the lien of the United States for taxes and penalties shall have priority. S. Sec. 3263. The law not only imposes these heavy penalties for any attempt to evade the internal revenue laws, but it imposes restrictions, which if carefully and properly enforced, will go far toward preventing the distiller from avoiding the payment of the tax. It is provided that the process of distillation is to be carried on through continuous closed vessels and pipes, that the distiller must furnish the Commissioner of Internal Revenue a plan of the distillery showing the location of the vessels and pipes, and that at the end of each day, and before midnight, all spirits distilled during the day must be conveyed to receiving cisterns, which are in charge of and under the lock of an internal revenue officer known as a gauger, and can be opened only in his presence. Afterward the spirits are to be withdrawn, under the supervision of the gauger, from the cisterns into casks or barrels. Then the spirits are to be gauged, proved and marked, and immediately removed into the distillery warehouse, which is required to be maintained by the distiller on the distillery premises to be used only for the storage of distilled spirits of his own manufacture, and which is in charge of an internal revenue officer known as a storekeeper. The storekeeper has joint custody with the distiller, and the law provides that the warehouse shall at no time be unlocked, or opened or remain open unless in the presence of the storekeeper. In addition to these precautions, each distiller is required to give a bond, Government Form 30, conditioned that he will in all respects faithfully comply with all the provisions of law relating to the duties and business of distillers and pay all penalties incurred or fines imposed on him for a violation of any of the said provisions, and that he will not suffer the tract of land on which the distillery stands, or any part thereof, or any of the distilling apparatus to be encumbered by mortgage, judgment or other lien. R.S. Sec. 3260. A new bond is required to be executed on the first day of May each year. The effect of this bond is to guarantee that all spirits that may be distilled will be put in the distillery warehouse, and the distiller is required to give another bond conditioned in effect that the proper taxes will be paid on all spirits deposited in the distillery warehouse. This bond is called the distiller's warehousing bond, and may be given monthly, Form 80. Conditioned to pay the tax on all spirits deposited during the preceding month, or may be given annually, Form 359, conditioned to pay the tax on all spirits deposited during the year, such payments to be made within 8 years from the date of entry of such spirits for deposit in the warehouse. This bond continues in force until all the spirits deposited during the month or year, as the case may be, have been lawfully withdrawn from the warehouse. And if they are not withdrawn within 8 years they may be sold for the payment of the tax. Now it will be seen that if the gauger and storekeeper, both of whom are required to give bond for the faithful performance of their duties, comply with the law, there is little chance for the distiller to dispose of his product without paying the tax. Practically the only chance is to draw off some of the spirits by tapping the pipes or by other similar means. But in view of the forfeiture of property heretofore mentioned, and of the further fact that the law provides a penalty of fine up to $5,000 and imprisonment for not less than 3 months nor more than 3 years whenever any person removes, or aids or abets in the removal of any distilled spirits, on which the tax has not been paid, to a place other than the distillery warehouse provided by law, or conceals or aids in the concealment of any spirits so removed. R.S. Sec. 3296. It may be assumed that where a distiller has an established reputation and standing, and where the distillery is of considerable value, he will not attempt to avoid the payment of the tax. That has been the experience of the companies, and where a distiller is rated at $10,000 to $20,000. The bonds may be executed without hesitation. However, there are many distillers who do not come up to these requirements, and they present the difficult cases for an underwriter. In the South, particularly, there are many small distilleries, some of them little better than the famous illicit stills, which are of little value, and the owners of which have little or no other property. It has been found that such distillers will try once in a while to defraud the government, and they often impose a liability upon their sureties. If the distillery has a capacity of 30 gallons of proof spirits or less per day, the distiller may be exempted from the requirement that the process of distillation shall be carried on through continuous closed vessels or pipes, and is not required to furnish a plan of his distillery, so that such a distiller may more easily evade the payment of the tax. It has been found that attempts to evade the law are most often made where the owner of the distillery owns or operates one or more saloons. In that event the risk is extra hazardous, for he is very apt to use in the saloons some liquor on which the tax has not been paid. Distillers rated at less than the figures above mentioned are not particularly desirable risks, but bonds for them can, with comparative safety, be written where 1. The people owning and operating the distillery have clear records and a good standing in the community. 2. Where the distillery has been established say 5 years, and is worth from $3,000 to $5,000. 3. where the distillery is not in a section where people are in the habit of trying to evade the revenue laws. This is a very important consideration. 4. Where the distillers do not directly or indirectly own or operate any saloons. Careful investigation should be made on this point. Sec. 165. Fruit distillers' bonds. Liquor distilled from fruit, as well as that distilled from grain, is subject to an internal revenue tax, and a distiller of fruit brandy is required to give a bond, Form 3012, conditioned that he will faithfully comply with all the provisions of law and regulations in relation to the duties and business of distillers of brandy from apples, peaches, grapes, pears, pineapples, oranges, apricots, berries, prunes, figs or cherries exclusively, and will pay all penalties incurred or fines imposed on him for a violation of any of the said provisions. The effect of this bond is to guarantee that the internal revenue tax on all brandy produced by the principal will be paid. He may pay the tax each month as the brandy is produced, or he may, after it has been properly gauged, marked, branded and stamped, cause it to be removed to a special bonded warehouse. In that event he need not pay the tax until the brandy is taken from the warehouse, but in order to acquire the right thus to put brandy in a special bonded warehouse and delay the payment of the tax, he will be required to give another bond, Form 235, Transportation and Warehousing Bond, condition that, as to all brandy removed from the distillery for deposit in any special bonded warehouse, he will safely transport the same to and deposit it in the special bonded warehouse, within the time and in the manner required by law and regulations, that he will likewise, upon the removal of said brandy from the special bonded warehouse for deposit in another, safely transport the same to and deposit it in the warehouse in which the deposit is to be made, and will well and truly pay the tax imposed by law, or cause the same to be paid, within 8 years from the date of the original gauge and before withdrawal. This bond covers all brandy removed during the current fiscal year ending June 30th, and a new bond is required each year. Each bond continues in force until all the brandy deposited in the warehouse during the year has been lawfully withdrawn. As in the case of distillers of spirits, there is practically no chance to avoid paying the tax after the brandy has once been put in a warehouse, as the storekeeper will see to it that the brandy is not removed until the tax is paid, and if the distiller does not pay the tax within 8 years, the brandy may be sold by the collector, and it will always bring enough to pay the tax. Likewise there is little danger that, after the distiller has entered brandy for deposit in a bonded warehouse, he will attempt to dispose of it without paying the tax, as the attempt would almost immediately come to the attention of the Internal Revenue officers, and he would have to suffer the consequences. The chance of loss under the warehousing bond, Form 235, is therefore rather remote. The other, Form 3012, is the hazardous bond, in that it covers the contingency that the distiller may dispose of some of the brandy without paying the tax and without entering it for deposit in a bonded warehouse, and it would be comparatively easy for him to do this, as there is no Internal Revenue officer to exercise control over the brandy, until it is entered for deposit in such a warehouse. It is true that a penalty of fine up to $5,000 and imprisonment up to 3 years is imposed for any act that would be a breach of the bond, but no forfeiture of property is provided for by law, nor is the distiller required by law to be the owner of the property on which the distillery is located. Although the Internal Revenue Collector is expected to see that no license is issued unless the licensee is the sole owner of the distillery, yet there are cases where the bond of some person, who was in no way interested in the distillery, has been accepted. As a class therefore these bonds are more hazardous than those of distillers of spirits, for there are many of such distilleries, and most of them are small and in remote sections, and as we have seen, the supervision of the Internal Revenue Officer is much less thorough. However, by applying the same tests as to distillers of spirits, the undesirable risks can, with fair accuracy, be eliminated. In this connection it is especially important to note the third requirement. In California, where the business is conducted on a large scale, and where the payment of the Internal Revenue tax is taken as a matter of course, there have been very few, if any, attempts to evade the law. On the other hand, in Ohio, New York and some other places, where the business is on a small scale, attempts to defraud the government are more frequently made. A good deal depends upon the temper of the people in the particular locality, and careful investigation ought to be made along that line. If in the particular section there is any evidence of a disposition to evade the law, the bond ought to be executed only where the applicant has unencumbered real estate worth the amount of the bond, or where satisfactory indemnity from the owners of real estate is received. Sec. 166. Transportation and Warehousing Bond. We have just seen that where a distiller of fruit brandy enters such brandy for deposit in a special bonded warehouse, he must give a transportation and warehousing bond, Form 235, conditioned in substance that he will safely transport the brandy to, and deposit it in, the special bonded warehouse, and that he will pay the tax imposed by law within 8 years from the date of the original gauge and before withdrawal. A distiller of spirits is required to give a similar bond, Form 351, in case he desires to remove the spirits from his distillery warehouse to a general bonded warehouse, the bond being conditioned that he will safely transport the spirits to and deposit the same in the general bonded warehouse, and that he will pay the tax imposed by law or cause the same to be paid within 8 years from the date of the original entry for deposit in his distillery warehouse and before withdrawal. These bonds cover all the spirits removed during the current fiscal year ending June 30th, and a new bond must be given each year. These bonds have not been found hazardous, for the reason perhaps that distillers are not so foolish as to attempt to divert the spirits from the warehouse to which they are to be removed when it is certain such diversion will almost immediately be discovered, and in all probability they will be sent to the penitentiary. After the spirits are put in the warehouse, the payment of the tax is not a matter that need give the surety any concern, for if the distiller does not pay the tax within 8 years, the collector may sell the spirits, and they will always bring the amount of the tax. These bonds may be written for any distiller of good standing. Sec. 167. Bond of proprietor of a general or special bonded warehouse. We have seen that a distiller of spirits may remove his product from his distillery warehouse to a general bonded warehouse, and that a distiller of fruit brandy may deposit the brandy in a special bonded warehouse. The Internal Revenue Collector of each district designates these warehouses. He may designate one or more, but not more than 10, warehouses in his district as general bonded warehouses for the storage of distilled spirits, and one or more, but not more than 10, as special bonded warehouses for the storage of fruit brandy. The proprietor of each of such warehouses is required to give a bond conditioned in effect that he will not permit any of the liquor lawfully stored therein to be withdrawn except upon the permit of the Collector of Internal Revenue, and when the permit is issued, the tax will have been paid. These bonds, though continuous, are not hazardous, for the reason, as we have seen, that each such warehouse is in joint custody of the proprietor and a government storekeeper, that it cannot be opened except in the presence of the storekeeper, and that the storekeeper is required to give bond for the faithful performance of his duties. Besides, these warehouses are usually quite valuable, and that of course serves as a protection to the surety. These bonds may be written in practically all cases without outside indemnity or collateral. Sec. 168. Bond for exportation of distilled spirits. The internal revenue tax on distilled spirits is required to be paid only in the event the liquor is to be consumed in this country. When therefore distilled spirits are to be exported, the distiller may remove them from the warehouse without paying the tax, but in order to get the permission of the collector to do so, he must, among other things, give a bond, Form 548, conditioned that the spirits shall be delivered on board ship, or cars, where the transportation is to be made by rail, on the arrival of the spirits at the port and within 60 days from the date of the bond, and that within 15 days from the date of delivery, he will produce to the collector satisfactory proof that the spirits have been so delivered, and duly inspected, entered, bonded and cleared, and that he will pay the tax on the deficiency, if any. These bonds, like the transportation bonds, have not been found hazardous, and may be written with the same freedom. Liability terminates at the end of 75 days. Sec. 169. Bond for the withdrawal of alcohol free of tax, under Sec. 3297, R.S. The law provides that alcohol may be withdrawn from bonded warehouses, without the payment of any tax, when it is to be used for the sole purpose of preserving specimens of anatomy, physiology, or natural history belonging to certain classes of institutions, or for the sole purpose of use in the chemical laboratory of such institutions. But the institution is required to give bond conditioned that the entire quantity of alcohol, so withdrawn, shall be used by the institution, or the proper officer thereof, for the purposes above specified, and for no other purpose, and that the principal will produce, within 24 months, to the Collector of Internal Revenue for the proper district, proof satisfactory to that officer, and to the Commissioner of Internal Revenue, that the alcohol has been so used. The bond further provides that, in case the alcohol, or any part thereof, shall be used for any purpose other than that above specified, the principal will pay, or cause to be paid, the tax on the whole quantity of alcohol withdrawn from bond, together with a like amount, in addition, as a penalty. The danger, under this bond, is that someone will use the name of an institution as a cloak to evade the payment of the tax on alcohol to be used for purposes not within the scope and intent of the law. It is therefore necessary to be reasonably certain that the institution is in good standing and in need of alcohol for the purposes specified in the Act, that the individuals who desire to withdraw the alcohol, in the name of the institution, are connected, in a proper official capacity, with the institution, and that they intend to use the alcohol for the purposes specified in the Act. If so, the bond may, with reasonable safety, be executed, especially since institutions of this kind usually have considerable property. The Collector of Internal Revenue is required to make an investigation as to the purpose for which the alcohol is to be used, and if he is not satisfied that it will be used for a proper purpose, he may refuse to issue the permit. This of course serves as a protection to the surety, and where the bond is small, an independent investigation by the surety is hardly necessary, but where the bond is large the surety should, for itself, make an investigation in the particulars above specified. Sec. 170. Bond for withdrawal of distilled spirits free of tax under Section 3464 R.S. When distilled spirits are sold to any officer or department of the federal government for the use of the government, the Internal Revenue tax is of course not required to be paid. But before a distiller can withdraw the spirits from the warehouse, free of tax for delivery to a government officer, he must among other things, give bond, Form 544, conditioned that he will safely deliver the spirits or cause them to be delivered to a named officer at a named place, and that he will within 30 days furnish to the collector a certificate of the named officer showing the due delivery of the spirits to him. In event of his failure so to deliver the spirits, he and his surety are obligated to pay the tax on all such spirits so withdrawn and not so delivered. The risk under this bond is about the same as under the bond referred to in the preceding section and may be written under the same conditions. Sec. 171. Denatured alcohol bonds. In general, under an Act of Congress of June 7, 1906, domestic alcohol may be withdrawn from bonded warehouses, without the payment of the Internal Revenue tax, for use in the arts and industries, and for fuel, light and power, provided the alcohol shall have been denatured, so as to destroy its character as a beverage and render it unfit for liquid medicinal purposes. Under the original Act, the denaturing could be done only upon application of a registered distillery in denaturing bonded warehouses specially designated for denaturing purposes only, but, by an amendment of March 2, 1907, the Commissioner of Internal Revenue may authorize the establishment of central denaturing bonded warehouses, other than those at distilleries, to which alcohol may be transferred from distilleries or distillery bonded warehouses, without the payment of the Internal Revenue tax, and in which such alcohol may be stored and denatured. In order to prevent this law from being used as a means of avoiding the payment of the Internal Revenue tax on alcohol, which is not in fact to be denatured for the purposes mentioned in the Act, the several persons who are authorized to handle denatured alcohol are required to give bond. These bonds will be separately considered. It is proper, however, at this point, to call attention to the fact that Section 2 of the Act provides in substance that any person who withdraws alcohol free of tax, under the Act, and removes or conceals the same for the purpose of preventing it from being denatured, and any person who uses alcohol, withdrawn from bond under the Act, for manufacturing any beverage or liquid medicinal preparation, or knowingly violates any of the provisions of the Act, shall on conviction be fined not more than $5,000 or be imprisoned not more than 5 years or both. In addition, any person so convicted must forfeit to the United States all personal property used in connection with the business, together with the building and lots of ground constituting the premises on which said unlawful acts are performed or permitted to be performed. Any breach of the condition of any of the bonds required in pursuance of this Act would no doubt come within the scope of the prohibitions of Section 2, and, in estimating the chance of loss, the probable punishment and forfeiture are to be taken into consideration. Sec. 172. Distilleries Denaturing Warehouse Bond. Form 572. Every distiller, who establishes a denaturing warehouse on his distillery premises, is required to give a bond conditioned that he will well and faithfully comply with all requirements of the Act aforesaid, and regulations issued pursuant to said Act, respecting the withdrawal, transfer, and denaturation of alcohol or rum, and will perform all other acts and render such reports as may be required by said Act and regulations, will pay on demand the tax of $1.10 on each and every proof gallon of alcohol or rum withdrawn for transfer to said denaturing warehouse as to which all requirements of said Act or regulations are not fully complied with, and will likewise pay all penalties incurred and all fines imposed on him for a violation of any of the provisions of said Act. The essence of this obligation is that the distiller will not, under cover of the Act, withdraw alcohol from his distillery warehouse without denaturing it in the manner provided by law. Having in view the usual value of a distillery, the fine, imprisonment and forfeiture provided for by the Act, and the close supervision exercised by the Internal Revenue Department, it may be said to be highly improbable that there will ever be a substantial violation of one of these bonds, and the chances are that a merely technical violation, with regard to reports for example, would not be enforced against the surety. Sec. 173. Bond for Central Denaturing Bonded Warehouse. Form 611. One who, under the Amendatory Act of March 2, 1907, establishes a central denaturing warehouse is required to give a bond similar to that required of a distiller who establishes a denaturing warehouse on his distillery premises. The liability and the hazard are substantially the same in both cases. Sec. 174. Industrial Distilleries Bond. Form 614. Under the Act of March 2, 1907, distilleries for the manufacture of alcohol for denaturing only may be established. Such a distillery is classed by regulation as an industrial distillery, and the proprietor is authorized to denature the alcohol himself or send it to a central denaturing warehouse for that purpose. He is required to give a bond conditioned in substance that he will safely keep the alcohol so manufactured until it is denatured or put in transit to a central denaturing bonded warehouse, that he will account for all the alcohol manufactured by him in a record provided for that purpose, and that he will denature, in accordance with law and regulations, all the alcohol that he may select and set aside for that purpose. The essence of this obligation is that all alcohol manufactured by him, must be denatured either by himself or by a central denaturing bonded warehouse. The hazard under this bond would seem to be no greater than under a distilleries denaturing warehouse bond. Sec. 175. Transportation and Storeroom Bond. Form 653. In order that consumers of denatured alcohol may conveniently get it in quantities suitable to their needs, it has been provided by regulation that such alcohol may be removed, by dealers, from denaturing warehouses and placed in storerooms specially set apart for that purpose and held for sale to manufacturers authorized to procure and use such alcohol for manufacturing purposes. In order for a dealer to get permission thus to remove denatured alcohol to his storeroom, he must give a bond conditioned, in substance, that, as to all such alcohol so removed, he will cause the same to be safely transported to his storeroom, and that he will safely store the same therein until lawfully disposed of. In event of his failure so to do, the bond provides that he shall pay $1.10 on each proof gallon, together with a like amount, In addition, as a penalty, he would of course likewise be subject to the penalties and forfeiture provided in Section 2. The risk under this bond is that the dealer will dispose of the alcohol to persons not authorized by law to use it, but his premises are likely to be of some considerable value, and, in view of the penalties and forfeiture above referred to, the chance that he will do so would seem to be slight. Beside, he would probably not proceed very far with such illicit sale before being discovered by the Internal Revenue Department. Sec. 176. Manufacturer's Bond for Specially Denatured Alcohol. Form 582. In order for a manufacturer to acquire the right to use alcohol which has been withdrawn from bond free of tax and denatured, he must, among other things, give a bond, which, after specifying the denaturer or dealer from whom such alcohol is to be obtained, is conditioned, in effect, that the entire quantity of alcohol so obtained will be used for the purpose of manufacturing the specified article and for no other purpose. In case the alcohol should be diverted from the specified purpose, the penalty imposed by the bond is the payment of the Internal Revenue tax of $1.10 per gallon on all the alcohol so diverted. However, such diversion would be a breach of Section 2 of the Act and would subject the principal to the penalties and forfeiture therein specified. It would seem to be highly improbable that any bona fide manufacturer, who must, of necessity, have an equipment of some considerable value, would, for the comparatively small profit he could make out of a diversion of the alcohol, lay himself open to the penalties and forfeiture provided by law. This bond is the one most frequently needed in connection with denatured alcohol, and it would seem that it might be safely issued for any manufacturer legitimately engaged in the making of an article requiring the use of denatured alcohol. Sec. 177. Brewer's Bond. Fermented liquors are subject to an Internal Revenue tax of $1.10 on every barrel of 31 gallons, and every brewer, before commencing or continuing business, must execute a bond to the United States, to be approved by the Internal Revenue Collector, in an amount equal to 3 times the amount of the tax on the liquors brewed by him during the period of a month, and conditioned that he will pay or cause to be paid, as provided by law, the tax required by law on all beer, lager beer, ale, porter, and other fermented liquors made by him, or for him, before the same shall be sold or removed for consumption or sale, except when removed as provided by law, and shall keep, or cause to be kept, a book, in the manner and for the purpose specified by law, which shall be open to inspection by the proper officers as by law required, and shall in all respects faithfully comply, without fraud or evasion, with all requirements of law relating to the manufacture and sale of any malt liquors. R.S. Sec. 3336. A new bond must be executed once in every 4 years, and upon the execution of a new bond, liability under the former bond terminates, except as to defaults committed during the 4 years it was in force. The payment of the tax by brewers is not surrounded by so many safeguards as is the case with distillers, there being no specific lien on the land and the period of imprisonment not being so long, but the law does provide that every brewer shall render to the collector monthly a sworn statement of the estimated quantity of liquors brewed and the actual quantity sold or removed, and further provides that any brewer, who attempts to evade the payment of the tax on fermented liquors or who fails to do any of the things required by law, shall forfeit all the liquors made by him or for him, and all vessels, utensils and apparatus used in making same, and shall be subject to a penalty of not less than $500, and imprisonment for a term not exceeding 1 year. R.S. Sec. 3340. The tax is required to be paid by means of stamps which must be purchased from the collector and affixed upon the spigot hole in the head of every receptacle in which the liquor is contained, and the same penalty is imposed for selling the liquor before the receptacle has been properly stamped or for using false stamps. R.S. Sex. 3343 44 46. In view of these penalties, and the value of the usual brewery, it would naturally be assumed that there would be few, if any, losses under these bonds, and that has been the experience of the companies. These bonds may be executed for any concern which is in good standing and has a fair credit rating, or which is the owner of the brewery and the land upon which it is situated, even though the property may be mortgaged for as much as 60% of its value. Sec. 178. Bond for the exportation of fermented liquors. Under an Act of Congress passed June 8, 1890, the internal revenue tax need not be paid on such fermented liquors as shall be exported to a place without the jurisdiction of the United States, but, in order to get the right thus to export such liquors without paying the tax, the brewer must, among other things, give a bond, Form 263, condition that as to all fermented liquor removed from the brewery or other place of storage for exportation, he will comply with all the requirements of the said Act of Congress and the regulations issued pursuant thereto, and that he will furnish to the Collector of Internal Revenue, within 90 days from the date of such removal, satisfactory evidence that said liquor has been duly entered for export and actually cleared for a port or place without the jurisdiction of the United States. In case of failure to comply with the bond, the principal and surety will be liable for double the amount of the tax on the liquor, but inasmuch as the liability accrues within 90 days, at the end of which time, the failure to export the liquor will become known, it may be assumed that no reputable brewer would try to divert the liquor and subject himself to probable fine and imprisonment, and double the ordinary tax. Such bond may be issued for any reputable brewer or brewing company. Sec. 179. Bond for exportation of specific merchandise under the Internal Revenue laws. We have seen that when distilled spirits or fermented liquors are exported from this country, no internal revenue tax is required to be paid. The same is true of tobacco, snuff, cigars and other articles which are ordinarily subject to an internal revenue tax. Any manufacturer engaged in the business of exporting such merchandise from the United States without paying the tax, must among other things, give bond, Form 549, conditioned that the articles so manufactured and removed for export shall be duly consigned to a collector of customs, and shall upon the receipt thereof by such collector, be entered for export from the United States, and that, within 90 days from the date of each such removal for exportation, he will produce to the collector the proof required by the regulations of the Treasury Department, showing that the articles so removed have been duly laden on a foreign-bound vessel or car, and that the said articles were actually cleared for a foreign port. In the case of all articles except tobacco, snuff, cigars and playing cards, there is an added condition that the principal shall produce satisfactory evidence that the articles have actually been landed at a port without the jurisdiction of the United States, or that after shipment they were lost at sea without fraud or negligence of the owner or shipper. The obligation to produce the proofs to the collector is not a serious or difficult matter, if in fact the merchandise has been exported. The only danger is that the principal will not export the merchandise but will divert it from its supposed destination, with a view of avoiding the payment of the tax, or will have it relanded at some other place. In practice, however, this has been found not to be a serious risk. The close supervision and vigilance of the Internal Revenue Department would probably make any such attempt futile, and inasmuch as it would subject the man making the attempt to fine and imprisonment, it is hardly ever attempted, especially when bond with corporate surety has been given. Sec. 180. Cigar Manufacturer's Bond. A cigar manufacturer is required to give a bond, Form 71, conditioned that he shall comply with all the requirements of law in regard to the manufacture of cigars, and shall not engage in any attempt, by himself or by collusion with others, to defraud the government of any tax on his manufactures, and shall render truly and correctly, all the returns, statements, and inventories prescribed, and whenever he shall add to the number of cigar makers employed by him, shall immediately give notice thereof to the collector of the district, and shall stamp, in accordance with law, all cigars manufactured by him before he offers the same, or any part thereof, for sale, and before he removes any part thereof from the place of manufacture, and shall not knowingly sell, purchase, expose, or receive for sale, any cigars which have not been stamped as required by law. R. S. Sec. 3387, This bond must be in a sum of not less than $2,000 nor more than $20,000, and is continuous, remaining in force as long as the license. The only way the bond can be terminated while the principal continues in business is for the Internal Revenue Collector to check up his stock, revoke his license, issue a new one and require a new bond. The penalties provided by law, in case of a breach of the bond, are imprisonment for not less than 6 months nor more than 2 years, and forfeiture to the United States of all raw material and manufactured, or partly manufactured, tobacco and snuff, and all machinery, tools, implements, apparatus, fixtures, boxes, barrels and all other material which may be found in his possession in his manufactory or elsewhere. R.S. Sec. 3372. In view of this penalty, and of the close supervision exercised by the Internal Revenue Officers, few, if any, bona fide manufacturers attempt to evade the Internal Revenue Law, and where an applicant for such a bond has enough money or property to warrant the assumption that he is acting in good faith and bears a good reputation, the bond may be issued. Sec. 181. Tobacco Manufacturer S Bond. Manufacturers of tobacco are required to give a bond, Form 40, similar in tenor and effect to that required to be given by a cigar manufacturer, and the liability and risk of the surety are substantially the same. Sec. 182. Tobacco Peddler S Bond. A tobacco peddler, as the name implies, is one who goes about the country selling and immediately delivering tobacco and cigars direct to consumers. In order to prevent such a peddler from handling tobacco on which the Internal Revenue tax has not been paid, he is required, among other things, to get a license from the Internal Revenue Collector and give bond condition that he will not engage in any attempt, by himself or by collusion with others, to defraud the government of any tax on tobacco, snuff or cigars, that he will neither sell nor offer for sale any tobacco, snuff or cigars except in original or full packages, as the law requires the same to be put up and prepared by the manufacturer for sale, and except such packages of tobacco, snuff or cigars as bear the manufacturer's label or caution notice and his legal marks or brands and genuine Internal Revenue stamps which have never before been used. Inasmuch as such peddlers go about from place to place, taking their goods with them, it is of course impossible for the Internal Revenue Officers to exercise much, if any, supervision over them, and inasmuch as they generally have little or no property, except perhaps a horse and wagon, there is really nothing to prevent these peddlers from handling tobacco on which the Internal Revenue tax has not been paid. However, the law does provide a penalty of fine up to $500 and imprisonment up to 1 year for any act that would result in a breach of the bond. In practice these bonds have been found not to involve much chance of loss. It is not certain whether this is because the peddlers do not in fact violate the law or because the violation is not discovered. In any event these bonds are considered desirable business, and may be accepted whenever the investigation shows the applicant to have a good record. The bond is continuous, but a new license is required each year, so that if that license is not renewed, the bond may be cancelled.